I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law, with offices in Orlando and Winter Haven, Florida. We handle trust litigation for plaintiffs and defendants throughout Florida. Today, I'm going to discuss how a Florida court decides the proper location for a lawsuit regarding a trust. Courts decide where a trust dispute is litigated according to Florida statutes. This is called venue for the lawsuit. Sometimes, by challenging that venue, because it may be an inconvenient forum, the venue may be moved. There are two Florida statutes that inform you where the proper venue for a trust dispute case should be. The general Florida venue statute says that a cause of action shall be brought in the county where the defendant resides or where the cause of action accrued, or if there's property involved, whatever county that property is located in. However, the Florida Trust Code states you can also bring the cause of action in any county where the beneficiary is suing or being sued, where a beneficiary resides, where a beneficiary has its principal place of business, or the county where the trust has its principal place of administration, which means wherever the trustee lives. There are multiple potential places where you could sue for breach of trust or actions arising or pertaining to a trust. However, just because a beneficiary technically meets the requirements of one of these provisions, that doesn't mean it's going to actually be litigated there. For example, let's say beneficiary A lives in Alaska, but the trust is cited in Florida and most of the other family members live in Florida. Most of the witnesses are in Florida, but beneficiary A files a lawsuit in Alaska. If beneficiary A is suing the trustee can file a motion called forum nonconvenience, which means an inconvenient forum, and challenge the venue. In a very basic way, the trustee is telling the judge, this is not a good place to litigate this case. Yes, there is a beneficiary in Alaska, but the trust is located in Florida. Most of the other beneficiaries are in Florida. Most of the witnesses are located in Florida. Therefore, Your Honor, the case should be referred to Florida to litigate. We shouldn't hold all of these other people responsible to travel to Alaska when there's only one person in Alaska that could come to Florida to litigate the case. Now, ultimately, the court will decide the proper venue for where to litigate. And disputes over venue often occur within Florida as to which county is the proper venue. For example, someone in St. Johns County may want to challenge a trust and files a lawsuit in St. Johns County. However, the vast majority of the witnesses may be in Orange County, and the trustee or another beneficiary could file a motion for forum nonconvenes to have it transferred to Orange County. Florida statutes set forth where a trust litigation venue can lie, and then you have a Florida Rule of Civil Procedures that says this is the process you have to go through in order to transfer from one venue to another. Again, I'm Reed Bloodworth, managing partner at Bloodworth Law. If you have a question about a trust dispute, give me a call. Let's talk about how Bloodworth Law can help you or your family.